Today we're going to discuss about the freedom of information that we filed with USCIS to get the data on the 485s that are pending, that are adjudicated in this year. We're going to also discuss about if your 485 is pending with USCIS, if you're contemplating to change the job, what are the steps that need to be taken, what are the precautions that you need to be taken. We're going to also discuss about the Biden administration's bold statement that they're going to reduce the processing time and make it easier and cheaper for the people to get their immigration benefits. Among the last but not the least of today's discussion is the million-dollar question about the H4 H4 applications that have been filed with the USCIS along with the H1B. Are they getting adjudicated along with the H1B applications? If you recall, before 2019, when the biometrics were not there, we used to get H1 and H4 and EAD also getting adjudicated along with the H1B. So we recently have this biometrics taken off. So we're going to tell you the results about that. Emily, USCIS used to have all the data published on the website of the USCIS. Hey, these are the number of 485 applications pending. This is the priority date of the peoples who have filed the 485, and this is the country of birth of those people. Why did they stop it? What is going on that?
Well, they never gave us any reason why they stopped it. I'm sure it was mostly under the Trump administration. Their transparency was not their forte. So we've really been wondering all this time how many people are actually in line. And that was great about that inventory is you could, based on your priority date, your country of birth, and your category, actually see how many people were in line ahead of you, and knowing how many green cards are available each year, kind of get an idea, ballpark figure of how long it's going to take. But we haven't had that data in years. So we've submitted a Freedom of Information Act request to get the information about all of those filings that were in October. How many have they even adjudicated so far this year? There's a big concern of green cards being wasted. We have all these extra green cards, which allowed us to file many more applications in October than anyone was expecting. But are they going to get to them all within this fiscal year? Because if they don't, those green cards are wasted. So we're wanting to find out how many they have adjudicated so far, how many they've actually received, and then who's in line. What are the priority dates? What are the country of birth? And what are the categories for everyone who has a pending 485 right now?
We should be getting a clear information from USCIS. If they don't give us within 20 days, we can contemplate on suing USCIS to provide the information. So this may throw a good light on how we can act, how you can act, how you can plan your life, how we can plan our lives too around you. So a lot of people need to know this information, and the USCIS used to publish this information before, and don't know why Trump administration stopped it. Hopefully so, with this freedom of information we filed, they are going to act just like the way, some of the steps our office did it. We were part of the class action suit. Stephen Brown from our office, one of the lawyer, and we were able to get the biometrics off on the H4 and L visas and E3 visas. Emily, we all know that when people have 485 application pending, and it's been pending for more than 180 days, they can change the job. Do you recommend changing the job when the I-140 is still pending? Because previously we used to have the I-140 approval. Now some of them didn't file in premium processing. Some of them premium processing got rejected. What do you recommend after 180 days if the I-140 is still pending?
Yeah, it's certainly safer to wait until the I-140 is approved before you contemplate that job change. There is a provision under AC 21 that says even if your I-140 is still pending, if your 485 has been pending for 180 days, you may still be eligible for AC 21 if you can prove that your I-140 petition was approvable when filed. There's no guidance or guidelines on how to prove that an I-140 petition was approvable when filed. So that kind of opens the door for USCIS to say, no, it wasn't approvable when it was filed. and then deny your 485 even if you waited 180 days to do the job change. So it's definitely preferable to get that I-140 approved, upgrade it to premium processing. If that gets rejected, keep trying. We are seeing them adjudicate these cases, even the downgrades, in premium processing eventually.
When you are contemplating to change the job, there are two other things that you need to notify. Is that if you're changing the job, make sure that you file the 485J supplement when you change to a new job. And if you do not have your EAD approved, when you change the job, you also need the H-1B to be filed, because 485 alone does not allow you to work for a different company. So you need that H-1B if the EAD is not approved. So please take these things in mind. If your EAD is approved and if your I-140 is approved, yes, it may be safer for you to move with the 485J supplement, but make sure that if the EAD is not approved, you should definitely do that. There are some lawyers who are telling that you don't need to file the 485J supplement. You only need to file the 485J supplement when you get an RFE. I am in a disagreement. I'm not telling that it's completely illegal for you to move. You can definitely move without filing the 485J supplement after the 180 days. You can definitely move. It is safer for you to file the 485J supplement. We have seen time and time again, the USCIS just looks into the I-140 withdrawal of the previous company, and they will just deny the 485 application because they don't see any other 485J supplement other than the one which may have been filed along with the 485 application. We have filed motion to reconsider. We have had situations where we went to the court and we got those things overturned each and every time. But do you want to do that? Do you want to go to the court? Do you want to file a motion to reconsider? There's also a danger that you cannot work in the interim period while we are making money on you. That's simply about it. I mean, I would recommend that you file the 485J supplement when you are moving. It doesn't have to be on the day you move. It can be a week or 2 weeks afterwards. That seems to be fine. But if you're not going to file until the RFE or denial comes in, that definitely is a danger. I mean, we have seen the USCIS chief saying that Biden administration is poised to decrease the processing times. They even had a public comments where what can we do to reduce the timings. What do you see the sincerity in this administration, or is it just the namesake that they're doing?
I see some sincerity, but it's not targeted to employment-based immigration. I think they're more concerned about asylum and that process, which is kind of a train wreck, as well as the situation at the border and dealing with DACA and all of these other issues and TPS, not really focused on processing times for employment-based immigration. Do you have any different opinion on that?
Yeah, well, I see that they have suspended the biometrics for the H-4s, L-2s, and E-3 visas. However, that didn't came from the administration. That definitely came from the court case, which Stephen Brown, our business colleague, was a part of it. Of course, they have still done some efforts, Emily, for example, giving deference to the previous H-1B approvals or L-1 approvals. That's definitely reduces the RFE levels and denials. I've also noticed that they have taken back some of the things. The Trump administration has said that they're going to be more restrictive on the H-1Bs. They have taken those things off. He also took it out of the menu, the H-4 EAD, which Trump administration said they wanted to. I have seen recently that they have increased the timings of the biometrics. The application support centers, they increased the timings to accommodate more people into that. They are doing the efforts, but it is not to the same level. When I have seen in the administration of Bush administration, when he came in 2000, oh my goodness, I've seen USCIS working on Sundays from morning 7 o'clock on Sundays, 5 o'clock I had to attend the 485 interview. It's just nightmare. I don't wake up in the morning. I'm not a good morning wake up guy unless it's a running thing or something like that. But I had to go at 5 o'clock in the morning. I haven't seen the drastic, dynamic steps that the Bush administration has taken. But I see a slow and steady progress, especially the ones which the previous Trump administration has initiated to intentionally delay entire immigration process so that nobody gets any benefits as much as possible. Definitely this administration doesn't have that intention, but yet I don't see the dynamic steps that need to be taken. And a lot of different steps that need to be taken. Like, for example, even though it's unofficially, they are not interviewing 485 people for the employment base, they didn't issue any official notification about that. So that's in limbo at this point of time. We are seeing that they could be using the biometrics that were done previously at the time when they took the fingerprints at the airports when they were coming in or when they get the stamping. I haven't seen them yet any green card approvals without biometrics though. Though in the Bush administration, Emily, what they did was that what they issued at that point of time was that we're going to issue the green cards even if the biometrics process is not completed. Back in old days, it was 15 months process. Bush brought it down to 15 days though, but it was 15 months process though. So what they did at that time was that we're going to issue the green cards without biometric process, and if we find anything wrong with these individuals, if they have any criminal records that you did not disclose them, they are going to cancel their green cards, and they did that for those things. I haven't seen those kind of dynamic steps yet I would say, but they can do it. I'm hoping they will do it. They definitely have a positive attitude towards the immigrations. So let's hope so in the next coming 3 to 4 months, they may improve more. Of course, COVID has definitely damaged. If Biden administration wants to do something, he's definitely very conservative on COVID. Before he came into power, he said he's going to be very restrictive on COVID. So maybe that might have hampered the things. We may expect something more coming in the next 2 to 3 months.
Yeah, and the American Immigration Lawyers Association annual conference is this week, and the USCIS DHS director is going to be attending that, and they have an open forum. So we'll see if we'll get some updated information from him on what the plans are for USCIS going forward.
Emily, from May 17th onwards, they said no biometric fees is required. They may not issue a biometrics notices anymore. For most of the people, in rare cases, they may still issue it. Before 2019, when the biometrics were being initiated, what I noticed, Emily, was that we used to get the H1, H4, and EAD approval at the same time. But I don't see the same thing happening afterwards, after the biometrics were being installed. Is there any results that we filed after May 17th, and then we got the H4 approval along with the H1B, Emily?
No, not one. We filed several H1 extensions, L1 extensions, along with H4 and L2 and EADs, and many of the H1 and L1s have gotten approved quickly, even without premium processing after May 17th, but not one of them received the H4 or L2 approval at the same time.
Can you explain the reason, Emily, why it is like that? What changed from previous administration to this administration that they're not adjudicating along with it?
Yeah, I mean, it definitely was.
I was thinking all the time that it was the biometrics that was the reason for it. Now it's not the biometrics. What's the reason right now?
Yeah, I don't think they have a good reason other than, well, once they instituted biometrics, they decided to have a separate corps of officers that handle just I-539s. It's separate from the officers that handle the I-129, and the biometrics was part of the reason for that. Well, now that they've split them, it's not as easy in their eyes for them to bring them back together because they've got a huge backlog of I-539s. They're hoping to get that backlog, the normal processing, down to 6 months in the next 6 months.
That's by September.
They're going to take, till the end of the year just to get the processing time of I-539s down to 6 months. Because, and I think that's really why they are claiming that they can't put the H4 along with the H1 and approve them at the same time, because they've got to get first in, first out through that backlog. I think they could find a way to do it. I mean, if an H1B I-129 officer can handle adjudicating an I-129, surely they can handle the I-539 that goes with it, especially when we have deference to prior approvals. how difficult is it to look at an I-539 of an extension for a kid? I mean, what are you adjudicating there? It's just, did I approve the H-1B? Then I can approve the H-4 for the kid and the spouse.
Yeah.
How
simple.
difficult is that? So hopefully we will see some modifications with that, but as of this moment, they do not seem to be moving in that direction.
Let's go to the question and answers. We get these questions. My wife, if wife and husband both are filing 485 with different employers, can we use the same medicals and why? Well, this is from CSKTVIT from Facebook. Here is the thing. Try to get two different medicals, two different original medicals. When you go to the doctor, if you're filing two different 485s, you can definitely get two different medicals. When you go to the same doctor, he's doing everything. All you tell him to do is that do one more 693 application form, and he doesn't need to do any changes in there, because unlike the other things, it's not that you're filing as a dependent or you're filing as a main application. No changes are required in it. You can get two original medicals and submit it with two different 485 application. Don't use the same one and pointing out to the officer, hey officer, go back to the other file. They won't do it. They are not efficient. They are not good. They are bureaucrats. What do you expect from them? They are not going to be that efficient. So please don't try to do the same thing what you do with your immigration lawyers with the USCIS. They are different.
Raghunath from YouTube is currently working on H-4 EAD. His employer also filed an H-1B, or her employer, and her husband's employer wants to know when that gets approved so they can withdraw the pending H-4, or maybe just the H-4. Do we really need to withdraw? No, there's no reason to withdraw an H-4. When you get the H-1B approved, your status automatically changes to H-1B. You don't have to go back and withdraw the H-4. Plus, the employer cannot withdraw an H-4. That's your spouse's personal application. It is not dependent on the employer. Now, if that H-4 is pending, it's an extension, and you've got the H-1B approved, then you need to look at the timing to make sure that you don't end up back in H-4 status, but you need to be very careful about if you actually need to withdraw depending on your specific circumstances. But in many cases, you would not want to withdraw and should not withdraw.
A lot of questions are coming, and a lot of questions will come in. A lot of questions came in before about the prediction of the priority dates. You already heard Emily is predicting somewhere between 2016. I'm predicting somewhere about 2018. We have gone wrong several times. We've been right sometimes. We've gone several times. Now, what are the things that you should do? A lot of people are asking. A person is asking me here. That is, Srujal is asking, my priority date is 2019. Should I downgrade right now or wait until the October visa bulletin? At our office, though, we are taking the cases only up to 2018. We are not taking the downgrade cases if it's 2019. Now, if some other lawyer is taking a 2019, I'm not telling that he's a bad lawyer. He may be a better lawyer than us. I'm not taking it. At this point of time, we feel justified to take the downgrade cases and file it early enough. A lot of people are asking, is it good to file early enough? Yeah, I think so. I mean, you may lose, if by any chance EB2 move forward and EB3 doesn't move forward, you can still use the EB2 application. If the EB3 is still pending, it's not approved, you can still file the EB3 and file the 485 application. Yeah, there are chances you might lose some amount of money. That's something that as an immigrant and as a person who has gone through the process, if I were you, I would be willing to do that thing. And also when it comes to the medicals, though, what to do? Should we do the interfiling or not? Lawyers are telling, oh, don't do it, do it. I mean, they're more concerned of saving some money for you, which I don't think so. They are bad lawyers, but it's just, you know, the things that they're more concerned about your money. I'm not. I mean, if you spend extra $500 if you have to, but if it saves 50% of the time and RFE of coming in and providing the RFE response, I don't care if you're $500, believe me, I don't. Because when I was an immigrant, I didn't. If needed, once I get the green card, I'll go work in an Uber in the weekend and a couple of weekends and make that money. That's what I am, but I don't want to keep continuing as a client of an immigration lawyer for a long period of time. I would rather do the Uber rather than come and listen to the immigration lawyer. That's what I am, and that's what I expect you to be. If you fall into that line, it may be worth for you to downgrade the application if it is 2018. If it's 2019, if you're a little bit more aggressive, it doesn't mean that you're bad. That's my opinion, but everybody has their own opinion. Anything what you have any different opinion on that, Emily?
No.
There are people are asking about, Adi Bhavan is asking the question, hey, my priority date is 2014. If I start my labor, what are the chances? Well, I don't know. If the prevailing wage is not done, by the time the whole thing will get, it will be about 1.5 year plus, it looks like. So it may cross actually up to September of 2022. One question that I have for Adi Bam for YouTube is that, can you go back to the old employer? Is that something that you can explore? If that is something that you can explore, you may want to consider. If that's something the previous employer's doors are closed, you cannot go back, what can you do? I mean, you just have to go with your current employer is processing right now. There is no speeding up the process. There is no premium processing of the labor certification. There is nothing like that. It takes its own. The prevailing wage takes its time, and there is a processing time. Once you file the labor certification, it takes its own time. There is nothing you can do about it. You have to, you just have to wait and nothing other than bothering, what can you do? You just have to wait.
Abhiram from YouTube wants to know, would there be any problem when I apply for an H-4 visa if I previously got a B-2 extension denied when I was in the USA? Potentially, but generally no. It really depends on the specific circumstances. There are particular questions asked in the DS-160 that you have to make sure you answer properly. If that denial of the B-2, you are still in the US and that denial puts you out of status, or your I-94 was expired at the time of the denial and you stayed for some time after that denial because you were waiting to receive it in the mail, you do have to answer yes, that you either failed to maintain status or overstayed the amount of time you were allowed to stay in the US. Those are two questions on the DS-160. You have to answer yes. Even if it was only for a day, you'll be able to provide the information. And as long as that out of status time or unlawful presence time, the amount of time you overstayed after your I-94 expired after the denial, as long as that's less than 180 days, you're still admissible for the H-4 visa or whatever visa you're applying for. So the main thing is you have to make sure that you do not have any ground of inadmissibility when you're applying for the H-4, which is usually more than 180 days of unlawful presence. As long as it's less than that amount of time and you disclose it properly on the DS-160, you still may be eligible to receive the H-4 visa.
One questions that a lot of questions are coming on the birth certificates though of India. I put a link out there, guys, just in case if you don't get the birth certificate, I want you to get 2 affidavits from 2 different individuals, preferably not parents, but any family, friends, cousins, or something like that. You can either get it from India or you can get it from here in United States. I have provided a link at the bottom of this video. We have also provided the drafts of those affidavits. I would also want you to get the non-availability certificate, which I have given a link there. If possibly you can. If not, you can still file the 485 application, but if possibly. But if you don't have the non-availability certificate, there are alternative documents that I have provided. Try to get them though. Try to get them, but we can file an application with an affidavits. If there is a small errors in the names, full name is not there, my dad's name is not spelled properly, my father's last name is not there, my mother's last name is not there, it's okay to use those birth certificates though. When you change the language from the Indian language to the English language, yes, there are some corrections that come. I mean, look at the way how the spelling of the words are. In South India to North India, it's different. So if an officer is South Indian sitting in the North India, he spells it differently. I'll tell you some of the examples of it. Anita. In the South India, we spell it as A-N-I-T-H-A. In the North India, we spell it as A-N-I-T-A. And there are a lot of things like that. It's okay if you have a mistake. If you have substantial other documents, I would not submit them. I'll keep them ready, and the substantial other documents are listed in the link that I provided. But one thing is that if there is any change, if the date of birth is wrong in the birth certificate though, don't submit that. That's very dangerous. I want you to contact an immigration lawyer before you do anything on that. But if there is any other clerical errors other than the date of birth, it's okay to submit it, and you can always provide the documents at a later date.
Priyanka from YouTube has an EB3 approval where the priority date is current, but she's outside the U.S. because of an H-1B denial. Wants to know, can I process my green card after I enter the U.S. anytime in the next few years? You really should consider, if that job offer is still available to you, starting the process of consular processing your green card. To do this, your employer will likely have to file an I-824 application, which will notify the consulate that your I-140 has been approved so that they can start your green card process through the consulate. The reason I say this is because once your priority date is current, you're no longer eligible for the 3-year extensions beyond the 6-year limit under AC 21. They assume that you're going to move forward with the green card, and why would you need to keep extending your H-1B every 3 years when you have a green card option available? So you may be limited in your ability to get back into the U.S. And may have to move forward with the green card through the consular processing. And also, if you don't seek to acquire the green card within 1 year of that priority date becoming current through consular processing and you're still outside the U.S., you may lose the whole thing. So that would be very risky to not do anything and just try to come back on H-1 and expect to be able to file your 485 after you return to the U.S.
Harry Caps from YouTube asked this question. My EB2 I-140 is approved in the consular processing. Is it better to downgrade to EB2 to EB3 so that or wait until my priority date become current? The fact that you filed the I-140 in consular processing has nothing to do with your EB2 to EB3. The judgment call for EB2 to EB3 is up to you to make. If you think so that the priority date is going to move, you want to prepare everything in advance, it may be appropriate for you to do that. If not, it's up to you. You can always, some of the employers will say, oh, we're not going to do it until when the priority date becomes current. We're not going to do it. That's okay. Stick with the employer. This is not the right time to change the employer. The employer is right in his own way. If he's willing to do it at the time in September, October, there's nothing wrong with it. But just because you have a consular processing doesn't make any difference. Even if people have filed their I-140s in consular processing, can they file the 485 adjustment of status when the priority date becomes current in the filing or final action date? The answer is yes. Just because you did in the consular processing does not prohibit you to file the adjustment of status or 485 application.
Orugala from YouTube wants to know, what is the workflow with USCIS when the priority date becomes current? Does the file need to move to the National Benefit Center or field office for the 485 approval? So they're going to be processing the 485, at least doing the initial steps, regardless of whether the priority date is current, regardless of whether the I-140 is approved yet. They're going to do those initial steps of intaking the 485, issuing the receipt notice, issuing the 485J receipt notice, adjudicating the EAD and AP, sending the biometrics, all of that. Once the priority date actually becomes current, as of right now, we're not seeing them transfer the cases to the field office because the field offices are not conducting employment-based interviews. I don't think we've had any client in the last year for employment-based actually be called in for an interview unless there was some sort of criminal issue when they're required to be interviewed. So it may stay at the service center where it's currently pending. And if there's medicals that need to be done, they'll send an RFE for the medicals. If there's any issues with birth certificates, marriage certificates, they can send an RFE for that. Otherwise, it's just a matter of them reviewing the file, and if everything is there, once the date is current and your I-140 is approved, then they can approve it right then and there at the service center. And we are seeing that happen. Others have been transferred from the National Benefit Center to other service centers just to even out the workload. Seen a few that were actually transferred to the field office, and then the field office sends the RFE for the medical and approves the case without an interview. I've had one of those RFEs just this week that came from the field office. So it varies depending on the service center and the officer.
Emily, I need your help in answering this question, though. Very, very tough question. He is getting his labor approved, and his employer, this is S. Dugineni from YouTube, and he has a previous priority date of July 2015. His employer will only file one I-140, not two I-140s. Its previous I-140 priority date is July 2015. Should he file an EB3 or EB2?
Oh, goodness. Why would you give me the hard questions? We can't answer that correctly.
Can
if
you
it
send
were me,
you? What would you do?
I would probably do EB3 because EB3 was already at January 2015 in October. You just got a little further to go. EB2 was only up to 2011. You've got 4 years to jump. Obviously, we don't know how many downgrades there were and how that will impact the movement of EB3. Will it slow down? Will EB2 speed up? We just don't know. Maybe once we get this I-485 data, we can have some better information.
Mr. Dugineni or Ms. Dugineni, I am not telling you what to do. If I were, I am leaning towards filing EB3, just like Emily. Not many times we agree on the priority date, though. But seems that in this time we both seems to be filing an EB3 if our priority date is July 2015, and if we get only one chance to the heaven, we will risk, and we both are risking in EB3. Now, don't come back in September, October, and tell us that we are wrong. Believe me, there are many times we are wrong, and it's not going to be new that you're going to tell us we're going to wrong in predicting the priority dates.
Chetan wants to know, my spouse's L2 visa appointment got canceled and she's not able to enter the U.S. Can she come in on her B1, B2 and then file a change of status to L2? There's some risk here. Generally, when you are, you're married and your spouse is in the U.S. on a work visa, it's expected that you come in on the proper visa, which is the dependent L2 visa. Now, there is a provision in the Foreign Affairs Manual that says that even though you are a dependent of an L1 holder or an H1B holder, for example, you may use a visitor visa to come into the U.S. if your intention is to come into the U.S. temporarily and return back. In this situation, she has no intention of returning back. She wants to come in and stay and change status to L2. So there's some risk there. I would not recommend people to do that because you run the risk of misrepresenting the purpose of your travel into the U.S. You may be trying to tell the officer, I'm just coming in temporarily and I'll go back home, so that you can get in and then file a change of status that says the complete opposite thing. So that's very risky.
How long should one stick with an sponsoring employer after getting the green card? 0 days, Mr. Krishna, 0 days. Once you get the green card, that's it. You can flip a burger in McDonald's. You can be a Microsoft CEO. Either of those things are good. Question from Nirav Shah. We have some answers for you right now. Can you please guide us, what should we do with the physical therapist prevailing wage, though? We're going to discuss on the Schedule A people that we had taken some wrong judgment calls previously. Emily, can you explain what happened with the physical therapist I-140 downgrade and what is the better approach right now?
Yeah, so we filed I-140 downgrades, and other attorneys have as well, in October with the 485 for Schedule A physical therapist, basically arguing that the labor certification in the previously submitted I-140 should be treated the same as any other labor certification and should be valid for you to file a duplicate I-140 petition and select a different category. People after doing that, many people upgraded to premium processing, and we started getting notice of intent to deny, saying that you did not submit a new prevailing wage, you did not submit a new notice of filing, you did not submit a newly completed ETA 9089 form, which is the PERM form that we fill out for Schedule A physical therapists. And so on top of that, several attorneys are reporting that they didn't even get a notice of intent to deny. After they upgraded, they got a direct denial. USCIS didn't even give them an opportunity. In my cases, I did get the notice of intent to deny. We did respond recently, and we have yet to get the result on that. We're hearing that potentially if you select amend for these type of I-140 downgrades. We talked about this before, that for a normal downgrade, it's not required to select amend. You can file a duplicate I-140 and have two valid I-140s, one in EB2 and one in EB3. Some people are reporting for Schedule A that if they selected the box to amend, the downgrade got approved. I don't have actual physical proof where I've seen this happen. People are reporting it, but some of these things have not been substantiated. So it is unclear at this moment where you have to select the box for amend. And if you do that you do lose the EB2. Your EB2 is gone and you can only move forward in EB3. Some people are okay with that. So I should have probably in about 2 weeks an update for you on whether my cases are being approved based on the response we're giving. We're basically arguing that no, an amendment's not required. We've used the Freedom of Information Act to get a copy of the labor certification as stamped by the USCIS officer confirming that they qualified for Schedule A, and that is considered a valid labor certification. So we're submitting that in response and saying, no, this is not a Schedule A case. This is a regular I-140 downgrade that should be treated like any other case that has a valid labor certification that is expired because it was submitted previously. So we'll hopefully have news for you in about 2 weeks.
People are speaking about the processing time for the prevailing wage and the labor certification. Prevailing wage time is about 4 to 5 months right now, or 5 months right now. And the labor certification processing is actually in the last week of November. I would say safely at this point of time, we definitely touched the first week of December. And maybe we are into second week of December for the perm labor applications filed in December of 2020 is what they're adjudicating right now.
Kieran from YouTube says the priority date is November 1st, 2011, but the receipt dates are incorrectly marked as December 2020. The I-140 has already been approved, biometrics are done. Is it safe to change employers since it will be 180 days? So you want to make sure on the receipt notice, the 485 receipt notice, that you're looking at the actual receipt date, not the priority date. USCIS does sometimes incorrectly put the priority date as the date that you filed the 485 instead of the old priority date, especially in downgrade cases. If the received date on your 485 is actually saying, December 2020, that's the date that you need to go by. It's unusual for USCIS to put a received date incorrectly.
Questions are coming with regards to the downgrade if their priority date is 2016, 17, or 18. It's relatively safe for you to downgrade. It may be prudent for you to downgrade if you want to. Why did we hesitate when we were telling the other gentleman when his priority date was in May of 2015? Why did we hesitate to say, ooh, either EB2 or EB3? Now, he said that he has only one option, EB3 or EB2. So there was a lot of hesitation there. When you're downgrading, if you are properly filing an I-140 application, you will have two applications ready for you, EB3 and EB2. So just in case, if by any chance EB3 doesn't move, because we both were going under EB3, maybe a lot of other people are also going in EB3. You can still use EB2. I mean, it's not that your EB2 is cut off. Your EB2 is still there. Even though you filed a downgrade application, you can still do the EB2. That's the reason why we are. One of the other explanation why Emily and I picked, if our priority date was May 2015, why we both picked EB3 over EB2 was more than 92% of the applications from Indian nationals are filed, more than 90% of the I-140 applications are filed under EB2. There were only 10% or less than 10% of them were being filed under EB3. That's a reason why we have chosen ourselves to go with EB3 than EB2 if our priority date falls in 2015. If you look into the stats of Chinese nationals, it's very confusing though. Sometimes EB2 goes forward, sometimes EB3 goes forward. When I've done a lot of the mainland Chinese nationals, what happened, I just recall driving in Los Angeles lanes, and my son lives in Los Angeles, so when I visit him, man, the lane that I go in, that doesn't move. And then guess what? After a while, I go to the next lane. Guess what? My lane that I moved stops. The lane that I moved from moves forward. Yes, it could happen with you guys repeatedly, again and again it may happen. I have seen that happening with the Chinese nationals. It could happen. So it's going to be very hard to predict because all the people who are eligible for EB2, they're also eligible for EB3. Even though 90% plus percentage are filing in EB2, they all can convert into EB3. And then EB3 stalls and it can keep going back and forth. It could happen. You will see that in 1 year from now or 2 years from now, you will see that going back and forth more.
Soham from YouTube got called for a biometrics appointment for the 485, but stuck in India due to the travel ban. How many times can I reschedule? I think that during the Trump administration, they would let you reschedule twice before they would consider it to be abandoned. I would hope the Biden administration.
I have had some denials where they requested the second time, Emily.
Yeah.
However, this time when you request though, make a special application, send it to them very clearly. Look, the person is stuck there. So don't reschedule it in the next 1 month. I cannot make it because of the travel ban. At least reschedule it in 6 months from now. That would be more ideal for you to come back into United States. Instead of just reschedule, if you tell them to reschedule, they'll reschedule in 1 month. I would specifically request them to reschedule for 6 months.
Chica Boy from YouTube wants to know, after 180 days, if I have an approved I-140 but no EAD, can I change jobs? Potentially. So if your 485 has been pending for 180 days and your new job is in the same or similar job category, you can change jobs, but you need employment authorization to do it because you don't have the EAD yet. That means an H-1B transfer, assuming that you are in H-1B status and had continued to maintain it after your 485 is filed. So you can do an H-1 transfer and the 485J supplement if you don't have the EAD yet.
A lot of people are asking about the process of submitting the medicals. We're going to give it to the people who come to the conference calls, which is free actually. So there's a conference call scheduled every day, Zoom conference call scheduled every day. So the link is provided there. If you come there, we're going to give you the sample so that you can use it to file the medicals, guys.
Kalyan from YouTube wants to know the L2 EAD renewal fees. He sent $410 with the application, however, USCIS rejected it. $410 is the correct filing fee for an I-765 for the L2 EAD. I would look into, was the check dated properly? Was it signed properly? Was it made out to Department of Homeland Security properly? Is it a check that expires after a certain amount of time? There are lots of weird things that can go wrong with filing fee checks.
Did you say EAD or L2, Emily?
He said EAD.
Okay, just want to make sure.
Yeah.
People are asking, I'm on H-1B status. This is from Carlton Ellis. And H-1B is not stamped in the passport, has a valid I-94. Can I go to Canada for 2 weeks and return under automatic revalidation policy? Yes, you can. There are some restrictions right now with regards to coming through the land border, but you can fly in. There are definitely restrictions with regards to the testings that need to be done before you come in, and when you go to Canada too. If you take care of those things, we don't see any problem with automatic revalidation right now.
Venkat wants to know, what's the typical and average percentage of duplicates in approved I-140s? As we know, many people, many of you probably have multiple I-140s approved based on every time you change jobs. And also your spouse may have their own approved I-140, and you may only use one of those to file the 485. So how many I-140s actually result in a 485? I don't think we have any actual data on that. Perhaps once we get this Freedom of Information Act information that tells us how many people filed the 485 based on priority date in October, November, December, and we can match that up with how many approved I-140s there are filed in any given time based on priority date, we can kind of see that, but I would guess 50%.
I would say a little bit more, Emily. There is a thing called duplicate when you move from company A to company B, Emily. There's also when spouse is there, is right? Husband and wife are there. If husband and wife, husband is changing two companies, file two I-140s, wife is changed in a company, she's filing two I-140s or one I-140 at least. So you have three, sometimes four, sometimes even more. I may rate it that at least 60, I think so, 60% of the people are duplicate. When I look into my own cousins and cousins' kids and I look into the families, I sit down, have a chat in the weekend, you know, that's what I do. And then when I speak with them, of course, I make sure that they file their I-140s, their things are current and all those things. Everybody of them have, wife and husband has two I-140s. Each of them have two on an average. The cousins and nephews that I meet, there are many I-140s only. I would rate it that 60% are duplicate. But I consider the spouse also as a duplicate here though. So that's what my feeling is, but as you said, there's no accurate data on that.
Mahesh from YouTube has an H-1B max out coming in July. Perm application is still in process. Planning to file a change of status to H4 to stay beyond July, and wants to know if I have to wait 365 days once my I-140 is approved. No. So assuming that your priority date is not current, then you either have to have your labor certification filed 365 days or more before you hit your 6-year limit, or an approved I-140, one or the other. So if your I-140 gets approved before you hit that 365 days, as long as your priority date is not current, you can change status back to H-1B and get a 3-year extension.
Employer change, do we need to file an employer name change, do we need to file an I-140 amendment? If the tax ID number changes, so definitely there need to be, it need to be amended. With regards to, Deepak has a comment from YouTube. Did you hear correctly that you said no interview for employment AOS in our year? She meant to say year means, year starts from October 1st for us. We have seen, I would say that, as Emily has pointed out, some of the criminal records and small crimes that are there, not the traffic tickets, but I don't want to mention the rest of the things, but there are some small crimes involved. We have seen less than 5% of the interviews to be done. Mostly those people who have some small criminal records, those are the only people from October of 2021. Even before that too, it was very less. I wouldn't say it's 95% were exempt, but it may be a little bit more, maybe 10% of the people were getting interviewed from June, July of 2021 20, a very less number of people. One thing, Deepak, I have to point out to you is that how do we know that the next guy is not going to be interviewed? How do we know more people are not going to be interviewed? We're basing on the RFE though. What kind of RFE I'm speaking about is that there are some cases there is a must interview. For example, if a US citizen marries a non-immigrant visa person, you know that there is a lot of bad, fraud involved in it. Some people do bad things to provide. So it is a must, they must interview them. It is absolutely a must for them to interview. They can't give the green cards without them. So when we are getting RFEs for the medicals though, the way they're not RFEs, that when they're requesting the medicals, they're asking, giving us an option. Hey buddy, you didn't provide the medical. Either you give us the medicals or you bring it to the interview. That's what we get it for the US citizen, spouses, and other family immigration visas where the interview is must. But when it is coming to the employment base though, they're not giving an option. They're just telling, hey, this is an RFE, it's a fundamental document. You did not provide the medical RFE, you give it to us. They're not giving an option to give it to take it to the interview, which is actually good news for my clients, because I assume that at that point of time, the officer has decided not to interview. If the officer has decided to interview, he would have given 2 options. He didn't give us 2 options. I tell my clients, open a champagne. It's good news for you. So definitely, we have seen a trend going towards no interview. It's not official, but when we look into the stats, it's almost there that they're not going to interview.
Gursimran from Facebook wants to know if the automatic I-94 validation while traveling from Canada to the US works even if the expired H-1B visa stamp is for a different employer compared to the current H-1B approval notice. Yes, it does. So automatic revalidation allows you to travel to either Canada or Mexico for less than 30 days. If you don't go for visa stamping, you can use your expired visa stamp for H-1B and your I-797 approval notice that has a valid I-94 with the same employer or a different employer, and use that expired visa to come in. The CBP revalidates it, meaning they bring it back to life for that moment when you're entering and assume that it's valid so that you can enter, and then it expires after you cross the border. So yes, it does not matter that the visa stamp has the old employer's name on it.
Here is a classic question from Ajay, and I want to take a little bit of time to explain this one. Rahul and Emily, I believe you mentioned about the predictions. Same thing with me, what you predicted about the 2015. My employer is giving only option for EB2 and EB3. My priority date is 2016. What would you do? Why would I tell different story for that gentleman and to you? Just because it's 2015 and 2016, it won't change, buddy. I mean, it won't. Believe me, it won't. There are a lot of people, I tell people that people who are in 2015, 2016, 17, 18, I tell the people, don't change the company even if you get a very good offer. If I were them, I will not change the company. Guess what? They pay a lot of consultation fee just to come and ask me the same question. Would you change? No. Just because you pay me the money, I'm not going to change my opinion. That's not the right way. Do you think so? That if I tell all lies here and correct statements when you pay me the money, is that a right thing for me to do? No, absolutely not. I'm not going to tell you a different story if you pay me $400. Absolutely, I'm not that kind of guy. So yes, please don't come paying the money just to ask the same simple one-line question. Rahul, would you change to a different company where if your priority is 2016 and you're getting $100,000 extra offer? The answer is no, I will not. Even if you pay me $400 consultation, I will not change to a different company. The story will be the same.
Harry from YouTube wants to know, what are the next steps if the EB2 I-140 was filed for consular processing and the priority date becomes current? I'm outside of the US. So for consular processing, that means once your I-140 petition is approved, notice of that approval is going to be forwarded automatically to the National Visa Center. When the priority date based on the filing date is being current or close to being current, they will reach out to you to begin the consular processing. They'll ask you to complete the DS-260 visa application form online, pay the visa fee. They will ask you to submit documents to the National Visa Center like your birth certificate, your marriage certificate, employment verification letter from your I-140 employer. You'll have to get police clearance certificates. You send all of that to the National Visa Center. Then they will verify that all of the documents are taken care of and then forward your file to the consulate for the interview to actually be scheduled, and you will attend your interview at the consulate rather than filing adjustment of status with the USCIS.
Nag from YouTube has this question. Emma says biometrics are scheduled, but I haven't received a notice. 485 has been filed in October 2020. Case is not updated though. I would try to call the number to see if you can get to speak with an officer. I would also raise a service request though, because you'll be protected if you raise a service request. If they issued a biometrics and you didn't attend, you are doomed, buddy. You are doomed. So that's the reason if you raise a service request, you will be protected. We have a protection. Hey, but if you raise a service request saying that I didn't receive the biometrics, you can't deny the application because I didn't receive it. So you may want to call, and if that doesn't work, raise a service request to protect yourself.
AK from YouTube wants to know, can we file the EB3 downgrade I-140 as a new petition before waiting for the filing dates? Absolutely. If you think that in October your filing date might become current, you can file that downgrade today and get your I-140 approved in EB3 now while there's no rush, and then just file the 485 in October when the date actually does become current. No problem with that at all.
A lot of questions about the downgrade. Some people who are in 2011, 2012, 2014, I mean, why did not you downgrade in October of 2020? That's my major question that pops up. I need to know why you didn't downgrade it before I can answer the question of what you should do now. Anything else, Emily?
Last question, Ramanuj wants to know, if there are tons of visas wasted this year, do you see EB3 and EB2 still moving at the same rate as last year? Yes, and the reason for that is it's last year's family-based wastage that causes this year's employment-based dates to move. It has nothing to do with wasting the employment-based green cards of this year.
But my question, Emily, is that there is a backlog of 485 applications in there. Would they consider that in moving the dates, though?
I don't think they would, because they still have the visas available for that number of people.
But, so by the time they predict in October, they are still in September at that time. Yeah, that's right. Thank you, guys. Anything else, Emily?
I think that's about it. So if we did not get to your question, or you'd like to speak with us in more detail about your specific situation, you can always set up a consultation with either of us or any of the attorneys here at Reddy Neumann by going to rnlawgroup.com. Our consultation page allows you to see our calendars and select a date and time that's convenient to you. And you can always subscribe to our newsletter at rnlawgroup.com so you get the latest updates every Wednesday on what's going on with immigration.
To pick a lawyer, though, we have very competent lawyers in our office, not just Emily and me. There are very competent lawyers in there. We have given guidance. Believe me, there are some lawyers, I mean, for example, Rayan from our office is absolutely very good in the I-140s. He's very good. He does like, I don't know how many I-140s, and all he does is I-140s. And we have people, Crystal from Labor Department, we have H-1B, Stephen Brown, we have Christina. We have a lot of these people. They do hands-on work much more, guys. So please pick not just Emily and me. There are a lot of talented immigration lawyers. If by any chance they don't get the things properly, they will come to us, and we will go to them actually more than they coming to us. We go to them to ask the questions. So we have given a chart there, which lawyers are good in what particular subject. You may want to look into the consultation page before you just pick somebody. Thank you.